Welcome back to the deep dive. Today, we are looking at a scenario that honestly sounds like it was ripped straight from a crime noir novel. We've got a murdered drug dealer, hidden compartments filled with cash, a bookkeeper left holding all the secrets, and a ticking clock that could determine whether she spends years in prison or walks away free.
It really is a cinematic set of facts, but, beneath all that drama, there is a very precise, very technical legal battle happening. And it all revolves around the statute of limitations in federal conspiracy cases. It's a perfect example of how these procedural rules can just make or break a criminal defense.
Exactly. And the central question we are tackling today is surprisingly tricky, yet it's one that I think anyone who watches legal dramas or maybe finds themselves in a sticky situation needs to understand. When does a criminal conspiracy officially end for a specific participant? If you want out and you talk to the police, does your confession have to be 100% perfect?
Does it have to be a total clean breast of every single sin to count?
Yeah, exactly. To count as a legal withdrawal.
That is the core issue. And to get to the bottom of it, we have a pretty clear analytical path for this deep dive. First, we need to define the black letter law, just the basics on the statute of limitations in these federal conspiracy cases. Second, we're going to dissect this doctrine of withdrawal and really focus on this idea, this clean breast doctrine.
And finally,
We'll apply all these rules to the Eighth Circuit case of United States v. Grimmett. We'll see if a partial confession is enough to start that clock ticking, or if holding back even a few details keeps you on the hook forever.
okay, let's unpack this. We hear about the statute of limitations all the time, on TV. It's usually a plot device where the detective is racing against time. But in the context of a federal conspiracy, what is the foundational rule we are working with here?
So the general rule is, it's relatively straightforward, at least on paper.
Oh.
For the federal conspiracy charge we're discussing, the statute of limitations is 5 years. This means the government has a 5-year window to bring an indictment.
Right, but 5 years starting from when? That seems to be where it gets complicated.
Yeah.
If a conspiracy lasts for 20 years, does the clock start at year 1 or year 20?
Precisely. The trigger is the key. So generally, the clock begins to run when the conspiracy terminates. When the crime is over, the objective's achieved, or the whole thing just falls apart. However, and this is the crucial exception for you to grasp, for an individual defendant, the clock begins to run the moment they effectively withdraw from the conspiracy.
So let me get this straight. Even if the gang keeps committing crimes for another decade, if I withdraw today, my personal 5-year clock starts ticking right now.
Correct. If you effectively withdraw and the government waits 5 years and 1 day to indict you,
I'm in the clear.
you're in the clear. The conspiracy charges against you would be time-barred regardless of what your former partners are doing.
That leads us to the next logical hurdle. What is legally required to prove withdrawal? Because I imagine it's not as simple as just deciding in your head that you're done. I mean, if I just stop answering the phone or I stop showing up to the secret meetings, is that enough?
No, absolutely not. That is a huge misconception. The general rule of withdrawal is strict. Mere cessation of activity is not enough. You can't just ghost the conspiracy. Silence is not withdrawal. To legally withdraw, there are 2 main elements. First, the conspirator must take an affirmative act. You have to do something.
And the second element?
That affirmative act must be calculated to defeat the purpose of the conspiracy, or at the very least, show a bona fide intent to withdraw. You have to show you are done. You have to disavow the criminal enterprise.
Okay, so I need an affirmative act. I can't just be passive. What are the specific methods for that? I assume I can't just post a vague status update about new beginnings?
Well, certainly not. The courts generally recognize 2 primary methods. Method 1, you communicate your withdrawal to your co-conspirators. You look them in the eye and you tell them I'm out. You explicitly sever the tie.
Which sounds incredibly dangerous, depending on who your co-conspirators are.
Extremely dangerous, which is why many defendants opt for method 2. You make a clean breast to the authorities. You go to the police, you confess, and you cooperate.
Clean breast. That's a very old-school legal term. It creates a very specific image. It implies getting everything off your chest, holding nothing back. Total transparency.
It does. And that brings us right to the nuance we're exploring today. How clean does that breast have to be? Does it require absolute, total honesty, or is there some wiggle room?
Let's test that concept. I want to set up a hypothetical for you to see where the line is drawn. Let's call this scenario the getaway driver.
Okay, I'm listening. Lay it out.
Imagine a guy who drives for a bank robbery ring. He's been doing it for a while, does 3 jobs, but then the guilt starts eating him alive. Or maybe he just gets scared. He walks into a police station and says, "Officer, I want to confess. I drove the car for the Main Street heist last week. We stole $50,000. He gives them the location, the time, the amount. But maybe because he's nervous or maybe he's still a little loyal, he forgets to mention they used a blue van. Or, more importantly, he omits the name of the guy who bought the ski masks. He gives them the core of the crime, but he holds back specific details. 5 years pass. Can the government still charge him?"
That's the perfect setup. And if we look at the logic of the doctrine, the omission of the van color or the mask buyer shouldn't negate the withdrawal.
But why not? He lied, or at least he omitted facts. He wasn't fully transparent.
True, but look at the purpose of the affirmative act. The goal is to show he's done and to disable the conspiracy. If his confession was enough to give the police the core of the crime, the heist, the money, his role, that is likely enough to defeat the purpose of the conspiracy. He has handed the government the tools they need to stop the crime ring.
So he doesn't have to be a human encyclopedia of every single criminal act.
Exactly. If the information he gave was sufficient to allow the police to investigate and indict the others, the clock should start running. I mean, the law wants to encourage people to come forward. If we require absolute perfection, if we say, you missed one detail so your withdrawal is invalid, nobody would ever risk confessing. They would just stay silent.
That makes a lot of sense from a policy perspective. You want to incentivize betrayal of the conspiracy. Now, let's see how this played out in real life. We're going to apply this to the case of United States v. Grimmett. So let's analyze this properly. First, what are the legally dispositive facts?
The timeline here is absolutely essential, so you really have to track the dates. The story revolves around the murder of a drug dealer named Elmont Kearns on June 27, 1989. The defendant is Patricia Grimmett. She was Kearns' girlfriend, and crucially, she acted as his bookkeeper.
A dangerous combination. So she knew the business inside and out. What happened after the murder?
Immediately after, in early July of 1989, Grimmett was interviewed by homicide investigators. This is our withdrawal event. She was distraught, and she started talking. She admitted she believed Kearns was a marijuana distributor. She admitted she kept his drug records, although she claimed, she didn't understand the codes he used.
Did she give them any actionable intel, or was she just playing the grieving girlfriend?
Oh, she gave them intel, a lot of it. She identified Kearns' runners, the guys moving the drugs. She identified a man named Dennis Moore who owed Kearns money and was actually later convicted of arranging the murder. She admitted to using cocaine herself, and perhaps most significantly, she revealed the existence of secret compartments in the house.
What was in the compartments?
Marijuana and over $300,000 in cash. She showed the police where it was and handed it over. She told Lieutenant Jerry Cassidy she would cooperate any way she could.
Okay, so that's July 1989. She spills the beans, identifies the runners, identifies the murderer, and hands over 300 grand. Why are we even here? It sounds like she cooperated fully.
Because of what happened 3 years later. In 1992, federal agents were investigating that associate, Dennis Moore. They re-interviewed Grimmett, and in 1992, she gave them new disclosures she hadn't mentioned in 1989.
What kind of new stuff? What did she hold back?
Well, she admitted she helped Kearns count the money, confirming she was more hands-on than she had let on. And critically, she admitted she knew that the word sticks in the ledger meant Thai sticks, a specific type of imported marijuana.
So when she said she didn't understand the codes in 1989, that wasn't entirely true. She knew exactly what sticks meant.
Right. And she admitted receiving personal cocaine deliveries. So, armed with this fuller picture, the government indicts her on November 14, 1994 for conspiracy to distribute marijuana.
I see the math problem. November 1994 is more than 5 years after July 1989. But it is less than 5 years after that 1992 interview.
Exactly. Grimmett argued the statute of limitations barred prosecution because she withdrew in July 1989. The government argued she didn't fully withdraw until 1992 because she held back information.
And what was the core legal issue?
The issue was whether Grimmett's July 1989 statements constituted a legally effective withdrawal, a clean breast, sufficient to start the statute of limitations, despite the fact that she provided additional incriminating details in 1992.
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements for us.
Okay, so the court applied the rule that a clean breast serves as an affirmative act of withdrawal. This rule has 4 distinct components or elements that you have to look at. First, the affirmative act. The defendant has to perform an act that shows they've ceased to act in the role of a conspirator. Second, the nature of the act. If the act is a confession, it has to tend to defeat the purposes of the conspiracy and show a real intent to withdraw. Third, completeness. Now, while clean breath sounds like full disclosure, the confession doesn't have to be exhaustive if it provides enough facts to defeat the conspiracy. And fourth, post-withdrawal conduct. The withdrawal is only valid if the defendant engages in no further participation in the conspiracy.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply that first element, the affirmative act?
Right, so the sub-issue here was simply whether that July 1989 interview even counted as an affirmative step. The government tried to downplay it, but the court looked at the sheer volume of information she provided. I mean, she voluntarily met with detectives, she exposed the secret compartments, handed over all that cash, and identified the runners. So the court concluded that, yes, this was a decisive termination of her role. They even noted she was ostracized by the other conspirators at Kern's funeral, which really reinforces that she'd ceased to act as one of them.
Understood. Now, what about the second and third elements?
Yeah.
Regarding the nature of the act and completeness. This seems to be where the government really fought back, right? Arguing that her omissions meant the breast wasn't clean.
It is. This was the heart of the fight. The government argued for strict compliance. They said, look, the 89 confession wasn't a clean breast because the 92 interviews revealed new details. They argued that because she minimized her role, she was still protecting herself and, by extension, the conspiracy. However, the court just rejected this rigid definition. The court noted that back in 1989, she provided information that was probably sufficient to indict, if not convict her. She gave them the runners, the money, the records. The court found she gave investigators enough to defeat the conspiracy if they had just chosen to pursue those leads vigorously at the time.
So the court effectively said, you had the smoking gun in 1989. The fact that you didn't know the exact caliber of the bullet doesn't matter.
Precisely. The conclusion on these elements was that the 1989 disclosures were sufficient. The fact that she gave more details in 1992 doesn't erase the fact that she effectively destroyed the conspiracy secrecy in 1989. She provided the core of the crime.
That's a crucial distinction. It doesn't have to be perfect, just effective. What about the fourth element, the post-withdrawal conduct?
So this is kind of a safety valve for the government. The sub-issue is simple. Did Grimmett do anything to help the conspiracy after July 1989? Once she made that initial showing of withdrawal, the burden actually shifted to the government to rebut it. And the court found that the government presented no evidence that she shared in any fruits of the conspiracy or participated in any way after July 1989. She was done. So this element is met in favor of Grimmett.
And after analyzing all the elements, what was the court's final conclusion?
The Eighth Circuit held that Grimmett made a legally effective withdrawal in early July 1989. Therefore, the 5-year statute of limitations began running then, and it had expired by the time of the 1994 indictment. The district court had erred, the decision was reversed, and the charge was dismissed.
Wow, that is a huge win for the defense. It basically says the government snoozed, so they lost.
Yeah.
But did everyone agree? What was the dissenting view on the definition of clean breast?
It wasn't unanimous. Judge Murphy filed a really strong dissent, and her analysis focused heavily on the literal meaning of clean breast. She argued that it means a full confession, period. Judge Murphy pointed out that in 1992, Grimmett revealed some serious stuff she'd hidden in '89, specifically that Kearns had cleaned out a debtor in Chicago and had traveled to Colombia to negotiate a drug purchase. Murphy's point was that by withholding this, Grimmett was still protecting the conspiracy and her boyfriend's reputation.
I can see that side of it. She was minimizing the damage to his memory.
Right. And from a policy standpoint, the dissent argued that a conspirator shouldn't get the benefit of the statute of limitations unless their disclosure is full and accurate. Basically, if you want the law's protection, you have to be completely honest with the law. You shouldn't be rewarded for a calculated confession where you give up just enough to look good but hide the worst parts.
It's a compelling moral argument. But the majority clearly felt that the practical goal of dismantling conspiracies outweighed the moral requirement of total honesty.
Exactly. The majority prioritized the defeat of the purpose over the purity of the confession.
So what does this all mean for us? If you're looking at this from a strict analytical perspective, maybe prepping for a law exam or a real case, how do we synthesize all this?
We can boil this down into a diagnostic checklist. If you're analyzing a conspiracy withdrawal issue, you need to follow these 4 steps to figure out if your client is safe.
Okay, lay it out. Step 1.
Step 1 is the timeline check. Look at the date of the indictment. Count back 5 years. Is the defendant's last overt act inside or outside that window? If their last act was 6 years ago, you have a potential withdrawal argument. If it was 4 years ago, withdrawal doesn't even matter. They're still liable.
Okay, check the dates first. What's step two?
Step two is the prima facie withdrawal. You need to find the affirmative act. Did the defendant just ghost the game? Insufficient. Did they confess to the police or explicitly tell the gang they are out? That is sufficient to start the analysis.
And once we have that act,
Step three is the clean breast test. This is where you apply the Grimmett standard. You have to ask two key questions. Did the confession provide enough info to defeat the conspiracy? And did it show a bona fide intent to quit? And remember, the big note from today's case, it does not need to be a perfect transcript of every crime. It just needs to expose the core of the operation.
and the final check.
Step four is the rebuttal check. You have to look for any participation after the claimed withdrawal, even a small act, taking a phone call, accepting a cut of the money, hiding evidence that resets the clock right back to zero.
That is a really powerful framework. It turns a messy fact pattern into a clear flowchart. And it really highlights that withdrawal is an active process, not a passive one.
Absolutely. You have to earn your way out.
So the big takeaway here seems to be that the law is, well, practical. It values breaking up the crime ring more than it values getting a perfect confession on day one. In the eyes of the law, you don't have to be perfect to be out, but you do have to be loud enough to defeat the purpose of the crime.
That's right. And if we connect this to the bigger picture, it really serves as a warning to the government. If prosecutors sit on a case or if investigators get enough info but decide to wait for more, that clock is ticking against them. In this case, the government waited too long, and a partial confession essentially became a get-out-of-jail-free card for Patricia Grimmett.
A fascinating look at how time and truth intersect in the law. That's all for this deep dive. We'll leave you with that thought. Sometimes telling most of the truth is enough to set you free if you tell it early enough.
Thanks for listening.
Yeah.
See you next time.